Thank you, thank you. Good evening. My name is John Russell. I'm a commercial barrister at Quadrant Chambers, and my QBiT talk is, what is economic duress? Economic duress is one of a number of ways in which a party may avoid or get out of a contract which they've entered into. There are a number of these ways, such as misrepresentation, undue influence, unconscionable dealing, and duress generally. And economic duress is obviously a subset of duress. Where it arises is if a party has entered into a contract as a result of illegitimate economic pressure, then they may rescind or get out of the contract. And it's then as if the contract had never happened. The court will seek to put the parties back in the position they would have been in if they'd never entered into the contract. So, what constitutes economic duress? Well, it arises where there is unlawful or illegitimate economic pressure, that's step one, where that pressure causes the victim to enter into a contract, that's step two, and then where the victim of the economic pressure has had no practical alternative but to submit to the pressure and enter into the contract. Now, it's important to understand why the law treats economic duress as a reason for allowing a party to get out of a contract. It used to be thought that the underpinning for it was that a party hadn't truly consented if they were under pressure. In other words, their consent was not real or was vitiated. But that's not the modern approach to duress and economic duress. The modern approach is to view it as proper consent. A party has decided to enter into the contract, but the law treats the pressure, which was illegitimate, as being a reason to allow the party to escape from the consequences of having consented to enter into the contract. And that's not a sort of an academic or ivory tower distinction. It has real practical effects. If the question was, has a party's will been overborne, so there's no true consent, then what you'd be looking at would be a subjective test analysing the way in which a party had come to consent and whether there was true consent or not. And that would be a very subjective test looking at a person's reasons for entering into a contract. However, under the modern analysis, the key questions are, firstly, was the pressure which was applied illegitimate or not? And secondly, was the victim left with no practical alternative but to consent to entering into the contract? And those are treated as being questions of law and therefore are to be determined objectively rather than subjectively. So an illustration of the importance of the distinction is the Supreme Court decision in Law Debenture Trust and Ukraine. This was a case in which Ukraine had issued Eurobond notes to which the sole subscriber was the Russian Federation. And Ukraine sought to avoid or rescind the notes on a variety of grounds, including both physical and economic duress. In relation to economic duress, the Supreme Court held that economic threats by way of trade restrictions in pursuit of political objectives could not constitute duress, since they were not inherently illegitimate and would not be rendered so by virtue of their being in breach of international law. Economic duress had to be assessed by reference to illegitimacy as a matter of English law, and international trade restrictions were not a matter on which English law could take a view as to legitimacy or illegitimacy. And also, of course, it didn't matter whether Ukraine had submitted to pressure and had not truly consented. It was an objective question as to the legitimacy of the threats. So the question of whether economic pressure amounts to economic duress is a question of law. What's the legal test? It's a threefold test. First of all, the pressure has to be illegitimate. Secondly, the pressure must cause the victim to enter the contract. And thirdly, there must be no practical alternative for the victim other than to enter the contract. There are three broad types of illegitimate pressure. The first is a threat of criminal or tortious nature, such as blackmail. That's a relatively straightforward case. Secondly, there are threats of unlawful but not criminal behaviour, most obviously threatening to breach an existing contract. And then thirdly, there's what's called lawful means duress or lawful act duress, which is where there is no threat to breach an existing contract, but there is economic pressure that is exerted that is nonetheless considered to be illegitimate. So if we take the case of a threat to breach a contract, this is where the perpetrator says that they will not perform an existing contract unless the victim of the pressure pays more or perhaps enters a new or additional contract. What's clear is that it's not every threat to breach an existing contract that will constitute economic duress. What's less clear is what threats do constitute economic duress. There are a number of principles that seem to apply. The court has to carry out an evaluative judgment as to the illegitimacy of the conduct. And this will be highly fact-specific, but obviously approached on an objective basis. Relevant factors will include the unconscionability of the threat. Essentially, how unreasonable is it in all the circumstances? And this ties the concept of economic duress closely into the equitable concept of unconscionability, which is another reason why parties may be able to escape contracts. Also relevant may be whether the person making the threat to breach the contract is acting in good faith or bad faith. Now, if we then turn to lawful means or lawful act duress, the existence of this as a category of economic duress was definitively established by the Supreme Court in a case called Pakistan International Airline and Times Travel. But it is perhaps even less clear here what factual circumstances will satisfy the standard required for economic duress. In practice, I think it's going to be a rare, or perhaps even very rare case where lawful means duress is successful in enabling a party to escape a contract. And that's in part because English law has no general principle of inequality of bargaining power or good faith in commercial negotiations. And so there's a general tendency not to allow parties to escape contracts on those grounds. If we turn then to causation, the causation test is a straightforward but-for test of causation. The victim of the alleged duress has to prove that if the illegitimate pressure had not been applied, he would not have entered into the contract. It's not enough to show that the pressure was one of a number of factors that caused him to enter the contract, if he would still have entered the contract if the pressure had not been applied. But it's not necessary to show that the illegitimate pressure was the predominant cause or the main reason why he entered the contract. A but-for test is all that is required. And then thirdly, the concept of no reasonably practical alternative to submitting to the pressure and entering the contract. Now this is obviously related to, and to an extent overlaps with the but-for test. If there was a reasonably practical alternative, it'll be hard to establish the but-for test of causation. But it is an independent requirement on the authorities. And again, importantly, what constitutes a reasonably practical alternative is a question of law for the court. The court will assess the reasonableness. And again, that is going to require a fact-specific evaluative judgment by the court. So, there we are. Economic duress is a means by which a party can escape contractual obligations where illegitimate economic pressure has been applied, and that has caused a victim to enter into a contract when there was no reasonably practical alternative but to enter the contract. However, what will constitute economic duress in any particular case is going to require a highly fact-specific evaluative judgment by the court. And that's economic duress.